Hello, everybody. Thank you very much for coming to kind of our joint Why Care About Intellectual Property event between Gust and a variety of people. So Moses Singer, I know, is where Milton, the firm Milton's at. David is independent, kind of on his own, doing IP strategy stuff. And David and Milton have worked together for a long time, it sounds like, from my correspondence with them. We're going to get right to the presentation, but just real quick intros. My name is Ryan Nash. I'm the CEO at Gust. Peter Swan's also here. He's our CEO. We're not experts in this stuff. We know a little bit about corporate back office structuring, but we get questions all the time about how do I get a patent? Who should do my trademark thing? How can I protect my IP? What is a trade secret? All this stuff. And so we thought today we'd bring in some experts to talk about that and run through a presentation. I'll be emceeing it, and I'll let Milton and David introduce themselves shortly. Throughout the presentation, I will be watching the questions in chat. So if you have a question, just throw it in there. The questions are usually the most useful area to put them. If it's contextually relevant, I'll throw it in, midstream. If not, I'll just let you know that we'll save it to the end. So we'll have some open Q&A at the end of the session as well. Without further ado, feel free to just introduce yourself in chat where you're coming from, see where people are at. But take it away, Milton. Give us a little bit of an introduction, and then pass it to David.
Great, thank you, Ryan. So as Ryan said, my name is Milt Springa. I'm a partner at the firm of Moses and Singer, and most of my work is involved with intellectual property, especially the big four: patents, trademarks, copyrights, and trade secrets. Also do things like plant patents, trade dress, but those are the big areas. And I do deals, litigate, and do foundation work. David?
I was Milton's partner for many years in a small boutique doing IP law, and I asked people to visualize IP as a tesseract, the cube being patent, trademark, copyright, trade secrets, the y-axis being litigation, licensing, and deals, the z-axis being the physics, chemistry, biology, software, and design of what you're doing different, all of it moving through time and space. And Milton and I have both practiced throughout those 64 cubelets, unlike most IP lawyers, which is why we think we have something to teach here.
Great, thank you, David. So without further ado, as Ryan said, let's head into the slides. And the title of our presentation this evening is Why Care About Intellectual Property? And during this presentation, we're going to be raising a number of questions. Some of those questions are, what's the benefit or payoff? What's the ROI? Are the benefits much greater than the costs? How do you care or think about IP better? These are the types of questions you should be asking when it comes to IP. We're not necessarily this evening going to offer specific answers to these questions. The point of this evening is to identify the questions so that the questions lead to awareness of the importance of getting IP right when it comes to running your business. David, you want to take it away?
You could think of these questions as a template or a series of blank forms that need to be filled in, but by filling them in and working through the forms, you're going to come up with better answers. So 3 big reasons to care more and do more about IP. Probably your startup is not based on the fact that you own the Empire State Building, the beachfront, a mountain pass, or something else that is a unique piece of land. Some businesses are, but most of the startups we see, that's not their basis, is I own the land. It's also not typically based on I own a unique piece of equipment at a special factory that can make things better, faster, cheaper than other people can. So if you think about 500 or 50 years ago when the Robin Hood and Sherwood Forest, who overowned the land, was the lord, and then the factories and industrial revolution, Rosie the Riveter, that's where the power is. Nowadays, the most big, important, interesting companies and most startups are not based on these tangible assets of stuff you can touch. It lies in the intangibles, the ideas, the thinkings, the way of doing things. And if those intangibles are protected at all, they're protected through intellectual property. Some, of course, can't be owned at all. So your business is a ghost business. It's based on intangibles, not stuff. And understanding that and understanding what you own and how to maximize its value is thus key to almost any business today. It allows you to understand the competitive landscape. What are the other people doing as opposed to what I'm doing? How do your intangibles fit into that? You can make better decisions going forward, and you have a map, if you will, of the minefield and are not crossing the minefield blindfolded or drunk or at midnight. Even with a map, it's dangerous being a startup, but it's a lot better than without one. If you don't understand the basics of IP, you can easily lose it. And as Milt referenced, building the right foundation is absolutely crucial. And doing some of these steps early is really, really important, or you can lose rights. Other things can wait, some things can't. And even if you aren't thinking hard about IP, at least some of your competitors might be. And you could be at the receiving end of a lawsuit rather than at the firing end, both of which could be unpleasant, but both of which might be necessary, both of which can happen. And if you're not prepared, it's going to hurt. I understand lawyers are expensive, annoying, and slow. Patents are expensive, annoying, and slow, and patent lawyers are doubly cursed. But if you think about your total budget pie, a suitable fraction of it can be devoted to be thinking about these intellectual property issues, not just patents, not ignoring, not delaying, not deferring, but gaining your fitness so the fights that are to come, you're ready for. Because if, as and when you succeed, you will be copied and you will be accused of copying. These fights are coming. So we'd like to think, can we have the next slide? That it's not just a painful necessity. That is the typical image that I find in a lot of entrepreneurs. It's painful, it's expensive, it can be put off till later. Please God, don't bother me about it. Maybe like a flu shot, or if that's contentious, some other thing. Exercise, you know you have to do it, but tomorrow. But those excuses are not going to benefit you and put you in the strongest possible position. So that, yes, there are many urgent needs for the money. You don't want to ignore any of them in terms of product service development and marketing and all the other things, understanding job to be done, all the things that are out there that we don't deal in. But getting the right amount of protection, those things matter. And they're actually at the heart of getting customers, getting profits, getting VC funding in ways that we'll try to explain. So understanding correctly how to use IP and translating it to your decisions, your actions, your tactics will actually maximize value of your business and its competitive edge, and thus be an important part of your success as an entrepreneur. Because again, the intangible differences and advantages are what lie at the heart of most businesses today. Next slide. We could have put Rosie the Riveter in here, or Robin Hood, but from factory to intangibles. Used to be that we would say about 80% of, say, Fortune 500, or when they try to calculate the values, what are companies worth, how much of that is tangible, 80% was intangible. Recent figures say 90%. So if anything, things are trending towards even more. Not land, not factory, not equipment, but the wealth is in the ideas and the differences that is most of your value. Which means if you're not running those things smart, you're actually not running 90% of your business smart. Designing the better product, more attractive form of entertainment, a better reputation in the market, all these things are what lead to big value. And part of a smart process for you, in terms of keeping track of those intangible assets, I abbreviate as DISV. Every quarter or whatever, list what is different, interesting, special, valuable, disruptive, innovative about what I'm doing as opposed to my competitors. And again, it might be you have a key location. It might be you have a really cool Italian espresso machine no one else has, but probably it's going to be intangibles. Next slide. This is one of those slides, charts that are out there showing more and more of the value lies in the intangibles rather than the tangibles. Now, the people putting this together have a vested interest in making that number as large as possible. But even if it's 50%, even if it's 30%, it's a lot. Now, again, if your ambition is to just start another nice coffee shop, that may be less than if you aim to, cure all disease or cure the clean tech problems of today. So, your percentage may vary, but it's likely to be big. And the percentage of value of the intangible assets as the S&P 500 has certainly grown, according to these numbers, from 20 to 80 to 90%. And this is likely, if anything, I think, to accelerate. Internet, COVID, telecommuting, a lot of trends push in having intangibles be more at the heart of a business than even it is today. Milt?
Thanks, David. So IP rule number one, Not only is copying allowed in the US, but it's encouraged unless you have an IP right. This concept is probably the single most important thing in today's presentation. If you take nothing else away but this idea, you will have gained something important. Many folks have a vague view that intellectual property is like cheating in grade school or plagiarism in college. In other words, don't take somebody else's work. Funny, that's not the law. No less than the US Supreme Court has stated that not only is copying generally allowed, but a free market economy encourages copying. Think about that for a moment. You come up with a brilliant idea, invest lots of time, money, and hard work to make it a reality, and the highest court in the country says everyone's encouraged to copy it. The only thing between you and somebody copying your intellectual property in you is intellectual property. And intellectual property is that unless in our slide. You need to have some positive right to protect your development, or your idea is free for the taking. So IP is value additive, we say. IP adds value to a business in at least 3 different ways. 1, creating and maintaining competitive advantage. 2, attaining freedom from competitor IP. And 3, understanding the competitive environment so you can make better decisions. Whether you intend to run your business long-term or develop it to the point of sale, understanding how IP can be implemented is crucial to exploiting it to the maximum. So, an insightful way to approach the question of how IP adds value is to envision a VC investor looking at your business and questioning you with some specificity about the foundation of your company. A good VC will want to know not only what your brilliant idea is, but how is it being and will be used to create value for your company? Asking the right questions for each of these 3 value-adding areas enables an entrepreneur to fully exploit its intellectual property. And whether or not your first VC actually asks you these questions lead you to better IP and IP strategy, and thus better sales, margins, profits, and value. And you can be sure these questions will be continued to be asked as your business grows. As an example, before a big company invests in you or buys your company. So 1, creating and maintaining competitive advantage. The most important function of IP is to create and maintain a sustainable competitive advantage. Why should anyone buy your product? Why will your products generate profits beyond commodity pricing? Why should a VC invest in your product? That's not going to happen unless your product is different, interesting, or special. And that is your sustainable competitive advantage. And that's why you need to protect it through using IP. So in determining whether you are using IP to create and maintain this competitive advantage, a good VC investor looking at your company should be asking you questions like the following ones. What differentiates your goods and services from your competitors? Why would customers want to spend their money with you as opposed to with your competitors? And if customers do buy from you, why should they pay a good price versus a commodity price without any premium? Or another question is, if your ideas are so great, what is it that keeps the competitor from simply copying your ideas? And then what efforts have you made to investigate what other IP is in your field? Should you be copying what your competitors are doing? Do they have weak IP? Or stated somewhat differently, can you avoid infringement by making small changes in your product? Or can you improve what you're doing by cross-licensing? Or can you efficiently infringe where remedies are weak and slow enough that you can take the risk? And in addition, why, especially in today's world, should someone with choices pick your place to work at all? IP helps in hiring good talent. So the flip side of this is attaining freedom from competitor IP. When you succeed, there's guaranteed there's going to be risks to your company getting accused of infringement. Competitors want to stop or slow you down, and competitors who own IP want part of your profits. And even if someday you win the litigation that you get involved in, it's a big distraction and a lot of noise. And when you're accused of infringement, it makes deals harder. So when looking at your company, a VC should also be asking you questions related to your competitors. What efforts have you made to avoid infringing others' IP, such as by design rounds? Who are your company's competitors? Who has an interest in stopping your idea, innovation from taking off? In other words, who will suffer the most financially if you're a big hit? What IP do they have or could they get? For example, could one of your competitors buy or license a killer patent that they can use to attack you? And why are you confident that you're not infringing? What due diligence have you done? In other words, why are you not buying an expensive and fruitless lawsuit? David?
Before David jumps in there, we actually have a relevant question that I think will be specific. Hugo Richard asks, would you say that Lyft copied Uber because Uber didn't do a good job with its IP, or is there some other reason for this?
That's one of my favorite examples, along with WeWork and Theranos, of what I would consider bad IP diligence. That the question was not sufficiently asked. Yes, it's an incredibly cool idea to share office space, take a drop of blood and know everything about your health, or use your phone and get a cab when you need one. And if it's raining, maybe I'll pay extra, but I'll still get the cab. Wonderful ideas. But given that in at least in the cases of WeWork and Uber, it was easy for other people to jump in and do more or less the same thing. The people who decided to value those companies, the billions, I think made a mistake. They got carried away by the black turtlenecks and the charisma and the enthusiasm and the fads, and not by a sensible analysis of what's going to make this business be different, interesting, special in the years to come. Whereas, for instance, pharmaceutical companies often do an extremely good job of thinking about protection over 10, 20, 30-year time periods. Sometimes too good a job, sometimes it verges into antitrust. So I think that's an absolutely terrific example. Slide 11, attaining freedom from competitor IP. Do you have any IP you can use for counterattacks? In our all-purpose checklist for litigation, what's the story, what's the most important documents, what's the worst and best case for validity, infringement, damages, etc. One question in the very basic checklist is, what will they counterattack us with? And you need to assume, if as and when you sue somebody, that you will get countersued. Sometimes it's stronger, sometimes it's weaker, but treat it as inevitable. Similarly, if you get sued, you want to be in a position to counterpunch. And if you aren't, shame on you, because you know these fights are coming, you know you need to be ready. And in a perfect world, each of you are holding the other guy's throat and you say, hey, let's work out a deal. I'll pay you 5%, you pay me 2%, whatever the right numbers are based on the value, and we'll keep everybody else out, and the two of us will dominate the market. And a lot of wonderful companies and wonderful deals have been formed that way. Another terrific example was the Wright brothers invent the airplane. Glenn Curtiss invents good airplanes that uses ailerons instead of warping the wings and has retractable landing gear and other advantages, and the two go at each other. And Glenn Curtiss can't make an airplane because the Wright brothers have the basic patents. And the Wright brothers can't make any good, modern, useful airplanes because Curtiss has all the improvements. And everyone actually knows the answer to how this turned out. The Curtiss-Wright Corporation, they merged because each had terrific leverage. So you've got to assume, like I used to in New York City in the 70s, I'm going to be attacked. And how am I going to respond? You've got to have IP Again, you won't win everything. You'll get surprised even with preparation, but what IP can you use for counterattacks? What way can you make your best defense a good offense? What would you be suing on? How would you be doing it? Is your improvement on this area incremental or truly disruptive? I love to use the image of better and better cars, electric, self-driving, whatever, and then someone invents the magic carpet. You sit on the rug and you fly to where you're going. You don't need a car at all. All the car pads go away in terms of being important. Be thinking constantly about what competitors would most like to kill you, i.e., the more disruptive you are, who is it that you're disrupting? How can you convince them it's better to invest in you or buy you or take a license from you rather than to wear you out and then buy you cheap? A typical situation would be you have this absolutely fantastic invention in a well-populated big company area. They sue you on everything they can buy or already have, and they wear you down for 2 or 3 years of $10 million a year, use up half, 2/3 all your time litigation. And 3 years in, they say for $100 million, we'll buy you. And at that point, you go, thank God. Where actually it was worth 300, 500, 900 million or more, but they, at the cost of say 30 million in legal fees, they've saved themselves hundreds. You don't want that to happen to you if there are sensible things you can do to reduce it. If it's not the arch competitor, it might be the so-called non-practicing entity or patent troll or university or someone who invented the technology but was unable to commercialize it successfully for a host of reasons. Those people just want a royalty, but again, tremendously affects your margins, your profitability, and thus your value. You can't countersue them because they're not selling something, but there are still smart strategies that can be thought through and used there. Next. We talked about this idea of the map and the minefield, but you can also think about IP as all these different competitors running towards different goals at different speeds and different directions and different starting points. And again, having some sense of what else is out there and what the map looks like. And remember, it's not a road map or a mountain map or a geological map. It's a traffic map, weather map, battle map, constantly in motion. Can make you decide, I'm going to head this way. I'm going to head that way. I'm going to try and make friends with this guy. I'm going to have to fight with this guy. I can go around this person this way. Knowing the landscape and what else is happening in your field can enormously help you make better decisions. And at least to the extent the VC or the private equity or the big company buying you is smart. And again, as the investor stage moves to later and bigger stages, they get smarter typically. They're going to say, what were your next 10 things to do? Of those, which 3 are you going to pick? How are you using IP to help make those choices? And if your answer is, oh, that's not a very strong answer compared to, here's how I'm thinking about it. I'm thinking about the right way and smart. So the landscape is not just an abstract or annoying step. It becomes a key business tool for the business people to make decisions. This is not what lawyers need to know. This is what business people and investors need to know about IP. What are you working on now? What are you doing to improve it? What are other people doing to improve it? What are the alternatives, like our magic carpet, or when I need to go to Boston, drive or motorcycle or train or fly or bicycle or walk? What are the other ways of getting there that make sense? What are you planning to do next? How are you thinking about triaging those to the ones you're actually going to do? And again, having your unique selling proposition or sustainable competitive advantage. Why buy? Why pay a premium? Why not be quickly copied by others?
I'll stop you real quick, David, because we have a pretty relevant question for that landscape
Great.
method, and this is actually something that I can chime in on with a personal story of what we experienced at Gust a couple years ago. We got, hang on, let me get there. Les Newman asks, he knows there are patent trolls who have developed IP or attained IP just waiting for someone to infringe. If we've developed a product that goes far beyond their scope, will they sue anyway?
Sure. Why not? You're an attractive target. There's a lot of weird and strange aspects to patents we're not going to get into now. Again, I'm not trying to teach law, but patents are not a right to do something. They're a negative right. They're a right to stop somebody else. So if you've invented, as the Wright brothers did, the airplane, all later airplanes infringe it, subject to your patents expiring. F-15, B-2 bombers, the Concorde aircraft. Uh, and so too with other inventions. DNA and RNA is an area I've gotten to do some work in, though not at the vaccine area. Happens in computer software, happens all over the place. And so inventions are often improved on as the patents layer up, but they still infringe the base. If you want to avoid infringement, you got to do something different enough. And the troll is thrilled to have you make the improvements. And of course, you'll argue the reason you get a 1% royalty, not an 8% royalty, is your contribution to the base technology is only 1/8 of the total value of what we're doing here. 7/8 is all the improvements we added on top. That's a nice fight. To the extent they can get an injunction, it's like, I've stopped you. Now talk to me. Though injunctions are ever hard to get. But yes, there's no reason in the world for the troll not to come after you just because you've improved it.
Yeah, and if I'll tell a quick story, something that we went through maybe 3 or 4 years ago, very specifically a patent troll. So Gust has this fundraising platform that's literally been around since 2004. We started in the early days with angel investors. We built out company profiles, deal making things, accelerator tools, and all that. And some company that was kind of a shell company acquired some patents to the right to create an online profile and raise money or something like that. Very vague, very like not really anything that anybody would recognize as somewhat enforceable. But they sued us in the Eastern District of Texas, which is apparently an area that sides with patent trolls quite a bit.
So
And
that more of them will sue there and bring business in. Right?
this is like why Delaware C corps. It's like, oh, because it's case law, but in this case, negative case law. But was to your previous point, I think Milton was going over the beginning of the conversation. It's like the time and money. It's like it was clear that the lawsuit was nonsense. They sued 10 other people in the space. So they sued anybody who had a fundraising platform. So like probably Republic and Seed Invest and yada yada yada. They came out with these suits with big numbers being like, oh, like clearly you've made millions off of this. But what we learned is in the process, like they settled for nominal amounts, $300,000 for a license of the patent or something like that, something that probably covered their legal fees. And we learned that their lawyers were actually not getting paid unless they agreed. Gust original founder, David S. Rose, would not back down. It took 2 years, honestly, almost $1 million in legal fees, which is ridiculous because that's more money than they were even suing for. But David knows a lot of lawyers. David was a very dug-in individual and a very principled person about this particular thing. And there was prior art all over the place. So it was like you couldn't even patent this. So not only that lawsuit, there's an Investopedia article or something like that, or a Crowdfunding Insider article on it. We had some journalists literally following us for like 2 years, just updating as the trial went on. And we eventually won. We not only won, but we won to recoup the legal fees that we spent on it. Still cost us money. Like it wasn't perfect. They're not going to true it all up and like give us extra money or anything like that. But I remember it coming up in like board meeting and management team meetings for years. And we're sitting there like trying to build products, trying to make partnerships, trying to make money. And like every month it's like, well, the lawyers came back and they tried to, move the court back to Texas. And we said, no, we've never been in Texas. We're in New York. All of our people are in New York. We don't even have an employee in Texas. And but like we had the resources to withstand that. Imagine you're a 2 to 3 year old startup who's just getting initial traction. Like, they'll size it up and go after it.
They'll pay the 300,000 and get the hell out of it, right?
Yeah.
And it's good to stand on principle, and it's good to make sure you're doing that for really sensible, non-emotional, Spock the Vulcan, rational reasons. When Samsung copied Apple, Steve Jobs blew his top, and the numbers I heard at the time was that by entering the market early with a copy, Samsung made roughly an extra $20 billion, of which they had to pay $5 billion to Apple in damages. It was still, as Milton referenced earlier, efficient infringement. It made sense for them to do it. And as smart as Apple is about IP and IP strategy, I put them absolutely at the far end of the Gaussian normal distribution bell curve, A plus. Was that a mistake to devote all that time, effort, and resources suing Samsung that could have been put into further improving the product, going next generation? There's a management distraction issue you alluded to a moment ago. And if it's, you've come up with a better credit card that competes with Visa and MasterCard and they sue you, right? It's a huge distraction on your competition to be dealing with this sued. Now, again, the troll doesn't want to stop you or distract you. They just want to maximize their royalties. The incentives can shift around. But if you had interesting competitors, there's no reason they wouldn't jump in, buy that patent, and use it to really cripple your management time. Because the one thing we know is with all the internet and all the Google glasses and everything in the world, we only got 24 hours in a day. It's an attention economy. And if you can distract the attention of your competitor, that's really good. You know, that's I'm in a karate match and I say, your shoe's untied. He looks down, bam. You know, distractions are really helpful. And you've got to think about how are you going to handle that. So we talked about this in overview in terms of understanding the competitive environment and the idea that a good VC will ask, what's the next best alternative? How is your invention better than that? And by how much? How much are people willing to pay for that difference between you and, you know, it's not as good, but it's good enough. And what are the alternatives that are coming that'll be out in a year or 2 or 3 from universities, from other startups, from big companies? And how are you keeping track of all that? And, you know, there is a 2-page article, Diligence in the New York Minute. The questions a good VC should ask, good angel, good private equity, are the same that a good CEO should be asking. It's just the diligence is the flip side of good management, of doing it right. Why are you buying my product at all versus, you know, you don't care about it? I'm getting some job to be done, something different, interesting, special, valuable. Why am I not going to pay a orange juice pork belly commodity price, but to pay a good, valuable premium price for it? What's sufficiently cool about yours as opposed to all the alternatives? Why do I buy that Patagonia vest for more than the LL Bean vest? As Milt alluded to earlier, why should talent that has choices choose to work here and stay here and not get lured away, except that you're cool, you're interesting, you're doing something special? Again, not because you own this piece of land or this piece of equipment. And the VC who's expecting the great exit, or any investor, angel, private equity, and of course your own time as a startup, why should they be thinking this is a winner, not a loser? And of course, the last step, the big company that buys you out or does an alliance with you or the IPO, why is there something there that's valuable and makes sense as opposed to doesn't make sense? Likely, it's not your land or equipment. Likely, it's your intangibles. It's the key to your sustainable competitive advantage. So if we can help you avoid the old, known, easy mistakes and seek a better way to enhance your profit and value, this has a huge leveraging effect on the company being run better. The same way a good company culture helps everyone be a great team and work better. I think, Milt, it's back to you.
Okay, so in summary, we started the presentation by asking the question, why care about IP? And we've suggested that there are at least 3 answers. Let's just look at them quickly. Value. Most business value today lies in intangibles, primarily intellectual property. So understanding what you own and how to maximize its value, it's got to be important to any business. Competitive landscape. IP allows one to understand what the competitive landscape is. How do your company's intangibles fit into that landscape and allow you to make better decisions going forward in terms of development and marketing? And 3, foundation. Foundation for IP is crucial. If you don't protect early, you may lose all or some of your rights. Thank you all for paying attention. Again, if there are any more questions, we'd love to work on those.
But we know your time is precious, so we'd rather go under than over.
I appreciate it. We do have a couple questions here.
Great.
One, as a follow-up to the kind of patent troll conversation, Lou asks again, if the troll has given us a number as to what they would sell the patent for, does that become a ceiling in a lawsuit, or could it grow higher?
I believe, though Milt does much more litigation today than I do, that settlement offers typically are not taken into account in terms of computing damages. In other words, you go to the jury and say, we always thought it was worth 100 million. We offered to settle for 50 because there's always a chance we could lose. It would take years. You know, our settlement offer does not reflect the true value. It's a compromise between the true value and the zero that they want to pay us. You should therefore not regard us. And I think there's a long and rich history of settlement offers not being admissible and not being used to squash damages. But I'll let Milt speak to that.
Yeah, and in fact, there is a specific federal rule of civil procedure that says settlement discussions are not allowed to go into evidence. So, you know, if you don't settle and you wind up taking the case to trial, it's quite possible that there may be a verdict larger than the settlement offer. That's what makes this game so interesting.
And they're sending signals, like in any business negotiation, with that number. And one of the things I've recommended, I think Milton and I have recommended for a long time, is early on come up with your settlement brochure, so you can walk into a conference room with the other side and say, here's what's probably going to happen. We're ready to go. This is the sort of number you might win, and your odds are only 20%. Therefore, 20% of this that's the value of the case. Whatever the arguments are, don't just be angry that there's a lawsuit. That's where people make bad decisions. I am Oz, the great and powerful. You are Dorothy, the small and meek. The hell with you. Big companies do both abuse other people's IP and make bad decisions about that because they get arrogant. And little companies get angry and feel like, how can people be doing this to me? Not the right question. What are the validity case? What's the infringement case? What's the damages case? How could I make change to no longer infringe? What are other things I could be doing? Let's make a rational business decision using the IP tool set to decide what to do here. This is not the first or last problem we're going to have. It's a problem that needs to be handled. There is a way of saying, as a defendant, making a formal offer, here's $10 million, I'm making an offer of judgment. You want $10 million, take it from me. And then if you don't recover $10 million, I get back some costs if your verdict is left, so-called offer of judgment. But I think it's a relatively minor tactic, but I think, Milt, you've used it with success from time to time.
It depends on what your cause of action. Sometimes those offers of judgment include attorney's fees, then they become real. But in most cases, you don't include those. So the costs you get back are,
minor, not major.
Yeah.
But it is a way of saying, I am confident and I stand here. And that's sometimes a signal you want to send. But rarely is full-blown end-to-case litigation in the party's interest. We lawyers love it. It's really interesting. It's really fun. It's really profitable. The sooner you can think through a business resolution that takes into account the inevitable uncertainties, get to it, and then go on with your business, I think the better off you are. And I don't mean to undercut Milt's business. If you do get stuck in litigation, hire him. He's fantastic.
We got a couple more questions here, and this one's actually pretty good for everybody. So maybe generalizing a bit on patents in general. But Dirk Tushama Roy asks, is a patent idea useful? It stays for 1 year. Can I renew it?
Provisional patent.
I believe that.
Yeah. So provisional patents are an enormous trap for the unwary because you think you can put in a sloppy piece of nonsense and then fix it up a year later when you go to a full patent. And the provisional is only as good as how well it actually teaches. And if you don't do it carefully, it can hurt you. They're super good for pharmaceutical companies where the 21st year of patent life is really important. For software companies, I question whether it's a smart strategy. You should just go directly. You can't renew them at the end of the year. You got to file. You can file a new provisional, but of course you lose the earlier filing date. It's a tool. I think it's sometimes overused because people think there's more savings and more power there. And I have seen, I think just the other day in a LinkedIn commentary strategy, people say, oh, get your provisional patent. It's a patent application. It is a request to get something. It is not a grant of anything from the government. It's not even examined. It doesn't issue. It doesn't give you rights. It is a tool in the tool set, but protecting your trademark, protecting your copyright, thinking about what can I license out early, what can I license in to avoid infringement, and protecting your trade secrets, cyber and physical, much more important than fussing about saving a few $100s on provisional versus full, in my view.
And it can hurt you because if you do a lousy job and then you're trying to rely on that provisional for your priority of invention, it's only as good as what's in there. And if the good stuff's not in there, it's just a waste. So you spent some money on the provisional. You can't go back to, when you file a non-provisional if it doesn't include the good stuff. So you really have just wasted a bunch of money.
And
But
I
it's got
think
to do it as carefully as you would a regular. Sorry, go ahead.
no, I think this actually might be a good clarifying point too, because we get this all the time in terms of what is patentable and what should you care about. And this will actually roll into Yvonne's question, which is uh, she's asking about the best practices when pitching an app idea to an engineer while still protecting it. And to roll that back into the patent stuff too is like, if I started a software app or I'm starting to build a website and it's a Ruby on Rails application, am I going to go patent my Rails code that I wrote or patent my app?
So there's a lot of software isn't patentable myths out there. And of course, if you look up what do Google or Microsoft or SAP or a zillion other software companies, they clearly own a lot of patents and they're getting patents and there's clearly patents on software all the time. My reflex is to always say, use all 4 or 5 of these rights to your best advantage, but here, file a patent application, but also confidentiality. Now, VC isn't going to agree to confidentiality. Potential employees that you're interviewing but haven't yet signed up, it's complicated. Maybe you'd say what it's going to do, but not how it does it. But be thinking about protecting both trade secrets and patents at the same time. And the courts have been hard on software patents, so it is tricky. And also, if it takes 3, 4, 5 years to get issued, often the world's moved on before the patent happens. On the other hand, a mere filing, even a bad provisional or a patent you don't have much faith in, can be helpful in saying to the VC, the angel, to employees, hey, we are protecting IP, we are doing stuff. It may not be perfect, but at least we aren't just sitting there like lumps. And again, it's a question of budget and allocating it thoughtfully and carefully. I believe, and Milt and his colleagues often said to me, who cares what you believe? It's the Supreme Court law. But I believe engineering is patentable. That is to say, applied science, solving actual, real, practical problems. There is an enormous body of law, which I think is poorly written, poorly thought through, poorly done, but it is out there, not saying that or saying that very poorly. And of course, similar rules exist in other countries, China, Europe, et cetera, as well. They sometimes say, is it a technical problem with a technical solution? But if you're trying to patent E equals MC squared or the Newton's law of gravity or anything else, you're not going to patent science. That's advancing human knowledge. But the application of that science to solve useful problems, which I'm shorthanding as engineering, generally is patentable one way or another. And a good patent lawyer will know which ways to phrase it under the current fads of the Supreme Court, Federal Circuit, and patent office. No?
No, I think that's absolutely correct. Yeah.
That doesn't happen often.
And
And
I'll
you just need to look at what it is that someone thinks is new and novel based on, what the Supreme Court has done, the Court of Appeals for the Federal Circuit has done, and then take it. So there's no generality. It's really what specifically, are they putting in front of you?
If you have a new proof that e to the 2 pi I equals 0 or -1, whichever way it works, that new proof is just mathematics or science, right? If you're figuring out how to build a better bridge or a better pair of Google glasses or something, that actually does something and solves again, it's like the jobs to be done thinking, a problem that customers are having. Usually there's going to be a way to patent it.
And I think I'll build on that from the early stage perspective in our kind of like startup field, and something that to Yvonne's question of like, how do I protect my idea? There's a big spectrum between like, I have an idea for an app and I have an invention that I can protect, whether it's an engineering invention, a physical product invention, or something like that. And I think you'll get a lot of times early stage founders, we're talking idea stage companies where they're just putting their sweat equity into it and they're starting to talk to early people in the ecosystem. In those cases, most startups are completely starved for attention. Like the idea of making somebody sign an NDA just to have a conversation about a running app that you want to create with like a slightly novel spin on, I don't know, incentivizing exercise or connecting partners or something like that. Those kind of things have been thought of by hundreds of thousands of people and pitched to investors all over the world. The vast majority of stuff at that stage is execution is everything. Like you don't have something if you have an idea,
Right.
but if you're actually going to execute on it and you're going to build value and you're going to hold that value into an entity, at that point you want to start to be strategic and thinking about how am I going to protect this? And a patent isn't the answer to anything. It's like one, I could keep it as a trade secret. If nobody gets access to my source code and I've done that novel thing, nobody has access to my source code. They could look at what I've done, but if they don't know how I did it, there's no reason to patent it, because a patent is just putting it out in public, being like, this is how I did it. And you get into some really weird situations where other countries with lax patent laws are like, you just published your trade secret so that your Russian competitor can come out and be like, ah, cool, boom, here's, Lyft, the Lyft version of your Uber. So I think that line is hard to like, you don't want to be, it's like you want to be paranoid in some areas when you have value to protect, but you don't want to be paranoid when you're trying to get people interested in your idea, when you're trying to hire an engineer, when you're trying to get to a VC. If you could pitch an invention worth patenting to a VC in a public meeting out of your mouth, that actually landed the deal, it's like you're probably already crazily successful. Usually it's like, oh, you'll pitch what you're trying to do, like, hey, we do a pinprick, we can get at-home blood analysis, this is our product. If you want to know how it works, maybe later we'll go into an NDA.
Exactly,
But
exactly.
believe me, further the conversation and things like that. One of the biggest things we get is founders wanting to get NDAs from anybody they share their idea to, and that's a huge flag on anybody who's existed in this space, to be like, oh, this person doesn't know what they're doing, or they're just
Exactly.
naive to kind of
Amateur
like
hour.
business. Right.
Well, this is
All right.
like the constant trade-off in startups too, where it's like you have to be willing to risk what you need to push the business forward, right? And often in these early conversations, or even when you're approaching VCs or angels to sell a piece of your company, like ideally you wouldn't be selling a piece of your company to get what you need to move it forward, but that is what you need to get the return or capitalize on the opportunity that you see. So all of this is a very like calculated risk, and at each step you have to be like, okay, I don't have everything that I need. What can I risk putting out there to convince people to give it to me?
Right. And saying we attain these results, and I'm not going to tell you exactly how we obtain them. I use a brownie recipe because I like brownies. Here's my delicious brownie. Wow, that's really good. I don't have to tell you exactly where I source the chocolate, what percentage I use, the temperature and the time of my baking, plus or minus X. There's a lot of information I can be holding back and still convince you that I've made a better brownie. And that's true of, many other products as well. And you've got to know, what sort of Series A, Series B, preferred debentures, voting rights. There's a whole lot of things that you guys know that are customary, that are normal, that are going to make, smart VC says this guy knows what he's talking about, as opposed to what the hell is going on around here. And the same thing's true of IP. It's a set of tools for you, the entrepreneur, and you, the investor, to use to help make better decisions. It should not be a reflex. It should not be automatic. It should not be, I'll patent it because it's patentable, as opposed to, I've thought through patent, trademark, copyright, trade secret, and licensing, attack, and defense, my 5x2 IP strategy summary. Here's why patenting certain aspects of this thing we think makes sense, though there's a risk. Maybe we filed on some, maybe we're seeking your money, investor, so we can file on the others. And you're right, a trade secret successfully kept works in all 195 countries perfectly, no litigation. On the other hand, there are a lot of other smart programmers out there, and if you do X, they can often sit down, look at that, and say, I don't even care how he does it, I can do it, and I can get you that result. And whether or not it's the same way doesn't even matter. For the customer's job to be done, it gets the job done. So you've got to think about what's going to inevitably be revealed, inevitable disclosure, if you will, versus what can be usefully kept back. And it all comes back to, again, why am I today and tomorrow different, interesting, special, valuable, as opposed to, that was nice, now I'll do it. I owned a Trio before there was an iPhone. It was a great gadget, but, right?
Awesome. So we actually, of course, in asking questions, we generate more questions. So we're going to move. Yeah, we're going to try to move. We got 10 minutes left, but we got about 7 questions to get to, and they're beautiful segues because that's how this stuff works. So Michael Lyons asks, are NDAs still needed after a patent has been successfully granted?
Yes, because you shouldn't have patented everything. You should be having a mix of patents and trade secrets. Imagine a DuPont factory and you patent steps 1, 3, 5, and 7 and keep secret steps 2, 4, 6, and 8. That's a great strategy. You ought to have a mix of both, and the NDA covers the stuff that isn't in the patent. There's also filing US only, which allows it to stay secret for a long time if that strategy is viable. I want to quickly mention that. Nope.
Yeah, exactly.
Okay.
Awesome. Kelvin asked a similar question that we were just talking about. I'm going to ask him if our previous discussion actually answered it. If not, Calvin, just shoot the question again or clarify on it. Les actually is just asking, what is the difference between a copyright and a patent?
So patent is on engineering. Trademark is your brand reputation, quality control. Trade secret is the secret sauce, typically recipes that aren't revealed in the final product. Copyright protects the expression of ideas, but never the ideas themselves. So you can write a book about your new scientific breakthrough. People can't copy the book, but they can learn the breakthrough. So when you have things that are in the arts, copyright is fantastic. You've written this book about a boy sorcerer, and he goes to school and whatever. You know, Harry Potter made a lot of money for everybody. Doesn't stop anybody from writing the next book about magicians and kids and adolescents, right? So you can copyright that software. So if that software is copied, I still have some CDs around. But if someone writes their own software to do the same thing, copyright doesn't get you anything. So it's a tool. It's not an everything.
All right, we got Sue Patel. Oh, go ahead, Milton.
And that's what, a good IP lawyer will help you out with. You don't come to him with, I just want a patent. What are the other things that possibly could be used to help the company? And that's, the landscape that you need to think about, just not limited to one IP right.
And related, we got Sue Patel asking, they're in the ideation stage, but they have a strategy for a key point of IP that's going to be software, but it's not completely developed yet. Can we still get a patent based on the idea of that? I think I'm going to invent something with the software.
If I figure out the circuitry that will make an anti-gravity car float in my garage, I can patent that without ever building it, right? You no longer have to file patent models and so on and so forth. If I'm right, and that when I do build it and the car floats, that's a really valuable patent application. And if I'm wrong, too bad about me. So I think your patent should be running ahead of your commercialization. Also, because once you sell, commercialize, publish anything that destroys patentability, especially elsewhere in the world, you have a 1-year grace period in the US. But you want to be patenting the stuff that we have a pretty clear idea that if we did this, it'd be great, it'd do work. And also first to file wins. So as you know, at least 4 different people invented the telephone almost simultaneously, and that's true for lots of other inventions, less well publicized. If you don't file, the other guy's filing. You're in a race with unknown other geniuses. Get that filing in. If you later decide to go US only or keep it secret or to modify it, but if you don't hammer the pitons into the wall, when you fall, it's going to be a much less pleasant experience. Falling with pitons is still unpleasant.
Yeah, I will say Pete and I both have an engineering background. One of the most humbling industries I have encountered. So the idea that you could write out an idea about a patent thing and then have that prove out in the actuality, not saying it can't happen, but I've been saying a lot of times in my life, like, oh, I could totally build that, and I think it would be exactly this way, only to be very sorely wrong very quickly in the details of that.
Hand, you may end up with 6 patents, and it may be hard for the VC to tell which one is right, and it may be that your second patent on an idea that you didn't use is the one that's effective in getting in the way of a competitor. It's often useful to patent some of your secondary or blind alleys, so reading your patents doesn't tell people exactly which way you're doing it. As part of a complete strategy, it's certainly worth considering.
Awesome. All right, we got just a couple more here. John Gormery asks, how do copyrights fit into software development? How hard to protect copyrights? The actual code, I guess, rather than like the brand.
Milt is an expert on this and has written on it extensively, but nowadays copyright, as soon as you write it, it's copyrighted. If you put the C in the circle, it's stronger. If you file it with the office, it's stronger. There's ways to file it with a so-called secure deposit. Think of an SAT test, your source code. And again, Milt is one of the world's experts on this. But it's worth making it not trivial for people to rip you off because you didn't take some very cheap and easy steps to protect the copyright side of what you're doing. But again, that only protects you against copying.
And you don't, as David says, you don't have to register, but registering gives you a couple of interesting things to think about. You can't start a lawsuit without a registration. And if you don't register early enough, you may lose treble profits and attorney's fees, if you get involved in protecting your copyrightable work. So there are advantages to registering, not that expensive compared to a patent, a lot cheaper than a patent. So there are good reasons for doing that.
Excellent. 2 more questions, and then I think we'll be right at time. Mara Santos asks, I've presented and published a new process for more than 1 year. Should I patent it if it's already in public disclosure, or can it no longer be patented?
I think it can no longer be patented, but most smart clients I've met are constantly improving. And your improvements may well be patentable, even if the original idea is out there. Just like here's the airplane. Imagine if the Wright brothers published it instead of patented it. But all of those things that make modern, very good airplanes weren't in that original teaching. If you haven't, you should certainly be trying to do it because other people are going to be trying to improve on it and build on it. But based on the 1 second of facts, if it's been out there a year, filing a patent is very likely a waste of money and possibly fraudulent, malpractice, at negative, not just a zero. I would be very careful. I'd get very precise advice for a lawyer. You may find that part of it you can't, but the newer stuff you can.
Awesome. Two more. So Calvin clarified his question. We were all around the discussion about sharing ideas and things like that without a patent. So specifically asking, is there something he should watch out for when sharing his idea, kind of seed stage startup idea, if they don't have a patent yet, or is there a certain time where it's a good decision to file?
It is for each client a difficult and individual decisions when to file. In general, it's a lot like voting in my beloved city of Chicago. Mayor Daley used to say, vote early and often. And the same thing is true of filing the patents. File on what you have today. 3 months from now, you've got it better. File on that 3 months from now. And then, you can go to the DC Angels and say, we have 4 patent applications. Most of them don't read them, understand them, work with them well. And just having the portfolio is going to help you. If to the extent you've revealed a trade secret, the patent gives you a backup position. To the extent you can, talk about results rather than methods, right? But remember again, Elizabeth Holmes used that as an excuse to say there is no method behind it. And a smart enough investor is going to say, I really need to know the secret sauce. And at that point, if you're that interested and you want to know that much knowledge, maybe you do need an NDA, even though we gave a public presentation about how wonderful this is.
I think,
or whatever.
yeah, sure. Just relating this to general startup advice. What we hear all the time is like people with ideas generally see the beautiful implementation of their future solution, right? They don't see like the original Twitter with the green logo that looked like slime and it only worked through SMS and all that. What they see is Twitter now, right? Toppling legitimate governments and inflaming the world. No, they see the thing in their mind, the invention, fully wrought out. So this is true with startups and with IP laws. Usually what you don't want to do is try and go and convince somebody, because honestly, even a lot of VCs and angel investors, if you're somebody who can create a novel invention, the number of people who might be able to understand how novel it is could be very small, possibly smaller than the amount of people necessary to put money into your company to actually give you the chance to build the invention. So results speak volumes, but you don't necessarily need the results of, Netflix's matching algorithm. Break it down into something. It's like, can you show results? Like the brownie example. It's like, if you can give a brownie to a VC and they eat it and they say, that is the best brownie I have had, I want to know more. And then you can say, well, I'm moving along on my IP protection. And so a lot of times you'll see a lot of successful startups. The first things that they produced is like one small proof towards a much longer path of proving out, a worldwide matchmaking system, a global, get a car by like pressing a button in your pocket. So really breaking it down so you can have those conversations. You can connect it to the big idea results, but demonstrate a little bit of success in like maybe a key first step that nobody's really done the way that would be necessary to do. But that way you don't have to share the trade secret, but you can at least demonstrate the result and get to that next conversation, get to a position where maybe.
Right?
Yeah.
Minimum viable product, which apparently doesn't mean most valuable player for baseball. That's fine. And again, nothing to me should convince a VC more than we have customers who are paying a premium price to already participate in it, right? Even though it isn't fully, and we need your money to do more. It's not. We don't just think people are going to love this; they already love it.
I think you both touched on something which I think is unique and valuable to how you presented this at the beginning. Even understanding the basics that you've presented today and how it overlaps with your competitive analysis and your business model canvas and how you're thinking about your business generally. If you can have an idea of what the path forward might look like based on your business and the things you've already generated to pitch, those are super useful to just communicate that awareness and that preparedness to investors. It doesn't necessarily mean that you have to go and patent something and max out a credit card to get a full utility patent before you have the money to do it. But you now have enough information to speak carefully, to understand how your business model and your business in particular could escalate through value add IP. You can communicate that, you can adjust your communication based on that, and at least you've thought about it. And honestly, having thought about this stuff in a structured way is half the battle oftentimes. You now understand what to think about, and you can calculate the risk that you're taking at every step and how that weighs against the reward of the conversation and the potential disclosure you're making.
And it's that structure that I want to share with people as much as possible, because these templates, these Blake forms, these organized ways of thinking about it are out there to be used. The answers are still hard. You're still walking, tight ropes, and it's still dangerous, and but at least you're not doing dumb stuff.
Awesome. We are at time, so I just want to give a brief for everybody, because I know some people might have to peel off. Thank you so much, Milton and David. We have one more question I'll get into after this, but I want to be sure most people can hear this. This stuff that David's talking about is very philosophically aligned with what we do at Gust and with Gust Launch. It's like we're that strategic approach and that kind of just planning out your path. That's what we do with Gust Launch for a company's back office. So basically, like, get yourself up and running, know what you don't know and when you need to know it, but like have a strategy, build your idea, knowing that you're a startup, you're facing ridiculous odds, early days, there's only 24 hours a day, you can only build so much, you can only know so much, you can only plan so much, but do the ones that will have the biggest impact. So when you're communicating your venture to other people and trying to bring them in, you feel comfortable and protected, and you know what risks you're taking. When you're granting stock, when you're managing things, when you're entering into contracts with people, you have this like base level of knowledge, so that you don't I forget what the example you do is like fall on your own infrastructure that you built, or have a very expensive cleanup, or just miss out on a big opportunity. So look forward for more stuff from us, both Milton, David, and the Gust team. We're probably going to try to deepen this thing and make some of these like stuff available to our wider audience. And before we get to this last question, because I think it's quick, but Milton, David, if you just want to say any farewells or leave the audience with anything to go with before we might lose everybody. They've hung on for the vast majority of this, so you have their ears for another minute, I think.
I'm impressed. Milt, I've been talking a lot already.
Appreciate everybody hanging out, and hopefully there was at least one thing that you took away from this that helps you in thinking about IP in your business.
Thank you so much, Milt. So the last question is, what's protected by NDS? I have to admit, I don't know what NDS stands for. Could be NDAs. Does NDA?
NDAs protect trade secrets in a word. Of our patent, trademark, copyright, trade secret scheme, NDAs are part of protecting confidential information, as opposed to the certificate of copyright, the certificate of trademark registration, the certificate of patent issuing. It's a non-governmental self-help step. Conan the Barbarian's father, who was actually a client, when he made really good swords, Conan was the client. He had trade secrets, how he made the swords, and he had a trademark. Conan's dad, maker of good swords, go to my hut, not the other hut. He didn't have patents. He didn't have copyrights. Those are more recent governmental rights. But reputation and confidential information are ancient. Archimedean fire, Damascus steel, silk, paper, lots of things.
Awesome. And shameless self-promotion, if you're going to start a company and you need NDAs, Gust Launch has them. And Milton is actually in our legal network, so we do matching on the platform for startups who need to get an introduction to a lawyer that's at the right thing. And you'll probably see more from all the three of us. And we're just getting thanks. Thank you very much, Calvin, for those kind words. And thank you, Milton and David. Pete,
thank you.
Thanks for hanging out with us too. Have a great night, and protect that IP.
Thanks, David. Thanks, Milton. Thanks, Ryan. Thanks for everyone for being here.
Yeah, see you guys. A recording will be sent to everybody in case you wanted to rewatch. Have a great week.